getting around today.
Good morning. The Subcommittee on Health, Employment, Labor, and Pensions will now come to order. Welcome, everyone. I note that a quorum is present. I note for the subcommittee that Representative Fred Keller of Pennsylvania be permitted to participate in today's hearing. I also note for the subcommittee that Representative Joseph Kennedy of Massachusetts will be participating in today's hearing with the understanding that his questions will come only after all members of the Health Subcommittee and any members of the full committee on both sides of the aisle who are present have had an opportunity to question the witnesses. Thank you for joining us. The subcommittee is meeting today in a legislative hearing to receive testimony on Protecting the Right to Organize Act. Modernizing America's labor laws. We call it the PRO Act. Pursuant to Committee Rule 7C, opening statements are limited to the chair and the ranking member. This allows us to hear from our witnesses sooner and provides all members with adequate time to ask questions. I recognize myself now for the purpose of making an opening statement. Today, we're gathered for a legislative hearing on how the Protecting the Right to Organize Act, or PRO Act, would protect workers' rights to organize unions in the modern economy. We had a hearing on the PRO Act just a few months ago. It is rare to have a second hearing so soon, but here we are today making this issue that is so important. This is a fight that we must engage in together on behalf of our hard-working Americans. They are our constituents, and they are counting on us to fight for them so that they can in turn fight for themselves and their families, fight to earn decent wages and benefits that enable them to care for their families, extended families, and for themselves. And I want to implore all of my colleagues on the committee to become co-sponsors of this legislation and then encourage all of the members of their respective delegations to sign on so that we can get this bill to the floor. Talk about this legislation during the August recess. I recently made a presentation before the Teamsters so we can get the word out to workers that we are on their side. This is a fight that we must fight in a consistent manner. And if we have to hold a third hearing on why the PRO Act is so urgently needed, we will do that. So let's do everything we can to keep the public, our congressional colleagues, the National Labor Relations Board, and others informed until everyone understands just how important this legislation is. Unions are essential for there to be dignity in and on the job. Protecting the rights to organize is critical for reversing decades of wage stagnation and income inequality. Yet, the rapidly changing relationship between employers and employees is undermining workers' ability to negotiate for better wages, benefits, and working conditions. Today's workers are increasingly hired not as full-time employees with middle-class jobs, but as independent contractors and permatemps. As our witnesses will testify today, employers exploit ambiguities and loopholes in the NLRA to prevent their employees from organizing unions, even though those employers controlled the terms and conditions of employment for their subcontracted employers. Rather than working to strengthen the right to organize in this changing economy, corporate interests and their allies in the Trump administration are exploiting weaknesses in this outdated law to aid their assault on workers' rights. For example, under the Trump administration, the National Labor Relations Board has further enabled employers to misclassify their employees. Earlier this year, the NLRB denied super shuttle drivers employee status because of their alleged entrepreneurial opportunity, even though super shuttle prohibited workers from using their vehicles to work for any competitor. And what if a worker has multiple employers? As our witnesses will testify, for many workers, the name on the door of the building where they work is not the name of the company that signs their paycheck. Thanks to the 2015 NLRB decision known as Browning-Ferris, both the user of permatemps and the supplier of permatemps can have a responsibility to collectively bargain with employees since they jointly control directly and through contractual provisions. These terms and conditions of employment for permatemps, that joint control makes them joint employers. However, despite an appeals court ruling that affirming this decision on the definition of a joint employer, the Trump administration is continuing its efforts to obliterate the court's direction through rulemaking. As the workplace becomes increasingly splintered, we must protect employees' First Amendment rights to free speech and protest, in addition to preventing employers from evading their legal obligations. The NLRA currently impairs workers' First Amendment rights by barring them from protesting for their right to unionize and from standing in solidarity with workers from other employers, which would be otherwise constitutionally protected. These laws prevent workers from peacefully protesting companies that do business with unscrupulous employers. As work relationships become more complicated, the First Amendment becomes even more essential for those workers to advocate for better pay and better conditions. But the Trump administration is seizing upon current law to further undermine workers' rights. The Republican General Counsel of the NLRB recently argued that workers break the law when they use balloon animals while peacefully protesting. This makes a mockery of our First Amendment. The organization of the workplace becomes even more splintered, and employers are able to exploit these arrangements to eviscerate workers' rights. The federal government has a responsibility to ensure that labor law continues to protect workers. The PRO Act would help achieve this goal by modernizing labor law to meet the challenges facing today's workers. The PRO Act would prevent the misclassification of employees by codifying a clear standard for when a worker is an employer or an independent contractor. The PRO Act also clarifies the standard for determining joint employment so that employers cannot evade their obligations under labor law. By codifying the NLRB's current standard, workers can hold each of their employees accountable under the law. And the PRO Act protects workers' First Amendment rights by repealing prohibitions on peaceful union picketing to guarantee organizing workers the same freedom of speech to which all Americans have a right. By passing the PRO Act, Congress and this committee would modernize our nation's foundational labor law to ensure that all workers can join together and bargain with employers for better pay and working conditions. I look forward to hearing from our witnesses and the discussion that will ensue. I now recognize the ranking member, Mr. Wahlberg, for an opening statement. The esteemed Mr. Wahlberg.
I thank the gentlelady, and thank you for this hearing. I think this is going to be a good hearing and appreciate the opportunity for the give and take that will go on. Thanks to a skyrocketing economy, and I think that is evident all across the board, propelled by recent tax cuts, innovation, regulatory reform, and American enterprise with great workers throughout the country doing the jobs that only they can do. Workers throughout this country are experiencing record-breaking success and opportunity. While workers' lives are improving, union membership rates have steadily plummeted, suggesting what Democrats refuse to acknowledge, that strong workers, strong union workers as well, and not strong union bosses, lead to economic prosperity. Workers' disenchantment with union representation has created a real crisis for union leaders, who instead of increasing transparency and accountability to serve their members better, continued to exert their political influence by demanding radical national labor laws. Union bosses and the Democrats who have their support want to use the power of government to further consolidate control, coerce workers, and bolster their personal agendas. And as evidenced by steadily declining union membership rates, that doesn't sit well with American workers. The bill we're here to discuss today, H.R. 2474, the Protecting the Right to Organize Act, or the PRO Act, is a sweeping labor union boss wish list designed to appeal to liberal Democrat primary voters rather than American workers in a modern workplace. This legislation is based not on innovative 21st century economy we are fortunate enough to enjoy today, but on the economic and workplace realities of the 1930s, when my father was helping to organize labor at steel mills in Chicago. And it increases the coercive power of big labor at the expense of workers and business owners. Among a list of dangerous one-sided provisions, the bill contains a card check scheme, the same undemocratic concept that was rejected by Congress the last time Democrats were in power. If a union loses an election, the legislation requires employers to prove they did not interfere in the election's results, a nearly impossible standard to demonstrate, which defies our nation's long-held principle that you are innocent until proven guilty. If an employer is unable to prove that it didn't interfere, a union is automatically ushered into the workplace without ever winning a secret ballot election. Americans select their representation in Congress by secret ballot, and congressional Democrats select their own leadership by secret ballot. But today they seek to deny the same right to Americans in the workplace. Where's the logic in that? Remarkably, the bill also requires employers to turn over workers' personal information. I wouldn't want that. The workers I know don't want that. They don't want me to know their personal information or call their personal phone cells. This information includes their home addresses, cell phone and landline numbers, personal email addresses, and more, without workers ever having a say in the matter. It also bans state right-to-work laws enacted by state legislators or citizens to allow workers to decide for themselves whether to join and pay a union. Laws that have resulted in more jobs and higher incomes for workers since being enacted in 27 states, including my home state of Michigan. The radical and coercive policies in this legislation are blatantly anti-worker and blatantly pro-union boss. Democrats are claiming that this bill will modernize labor law. In reality, H.R. 2474 amounts to little more than forcing more workers into one-size-fits-all union contracts and returning to a stale and old-fashioned 1930s-era view of the American economy and workforce. Unlike this antiquated, anti-growth, special interest viewpoint, Republicans believe that true modernization means expanding entrepreneurial opportunity and embracing flexible work arrangements and ensuring that union bosses are truly accountable to the workers they claim to represent. There's nothing progressive or modern about what Democrats are proposing in this bill. History has shown us that individual opportunity, innovation, and economic growth are what lead to real progress and prosperity for American workers. Americans are benefiting from the strong economy ushered in by Republican-led tax and regulatory reform. Wages are rising, unemployment is at near record lows, and millions of jobs have been created since President Trump took office. But the anti-worker freedom bill being discussed today would threaten this progress. Instead of more freedom and opportunity, it promises more coercion and red tape. Republicans on this committee will continue to stand with workers and promote individual freedom and pro-growth economic policies as the best path forward for workers, the best workers in the world, and job seekers, for increased jobs throughout this country. As I said, Madam Chairwoman, I appreciate this hearing. It'll be good discussion, even with disagreement. But we have to recognize the reality of what we're doing, and I yield back.
Thank you, Mr. Walberg. Without objection, all other members who wish to insert written statements into the record may do so by submitting them to the committee clerk electronically in Microsoft Word format by 5 p.m. on August 7, 2019. I will now introduce our witnesses. Welcome to you, and thank you so much for coming. Ms. Charlotte Garden is a professor of labor and constitutional law at Seattle University School of Law. Welcome. Mr. Josue Alvarez is a truck driver for XPO Logistics from Bell Gardens, California. Look, thanks for traveling so far. Mr. Roger King is a senior labor and employment counsel with the HR Policy Association. Thank you. Mr. Richard F. Griffin, Jr. is of counsel at the law firm of Breedhoff and Kaiser, PLLC. He also served as a board member and as general counsel for the National Labor Relations Board. Welcome. We appreciate all of the witnesses for being here today, and we all look forward to your testimony. Let me remind the witnesses that we have read your written statements, and they will appear in full in the hearing record. Pursuant to Committee Rule 7D and committee practice, each of you is asked to limit your oral presentation to a 5-minute summary of your written statement. Let me also remind the witnesses that pursuant to Title 18 of the U.S. Code, Section 101, it is illegal to knowingly and willfully falsify any statement, representation, writing, document, or material fact presented to Congress or otherwise conceal or cover up a material fact. Before you begin your testimony, please remember to press the button on the microphone in front of you so that it will turn on and the members can hear you. As you begin to speak, the light in front of you will turn green. After 4 minutes, the light will turn yellow to signal that you have 1 minute remaining. When the light turns red, your 5 minutes have expired, and we ask that you please wrap it up so I will not have to gavel you. We will let the entire panel make their presentations before we move to member questions. When answering a question, please remember to once again turn your microphone on. I will first recognize Ms. Garden.
Thank you. Madam Chair Wilson, Ranking Member Wahlberg, and members of the subcommittee, thank you for the opportunity to testify today about the need to expand the protections of labor law and to ensure that workers and unions can robustly exercise their First Amendment rights to engage in collective action. My name is Charlotte Garden. I'm an associate professor at Seattle University School of Law, where I teach labor law and constitutional law. My testimony today focuses on two reasons that the NLRA falls short of its promise to restore to workers equality of bargaining power and full freedom of association. First, the NLRA curtails workers' and unions' rights of free speech, association, and assembly by prohibiting certain secondary protests. Second, it doesn't do enough to respond to workplace fishing, including through subcontracting and misclassification. I want to make 2 points regarding the NLRA's ban on certain secondary activity, which generally covers strikes and picketing aimed at persuading businesses or consumers not to do business with an employer with whom a union has a labor dispute. First, in fissured workplaces, this restriction can force workers to act irrationally, focusing their attention on the small entities that are technically their employers, rather than the larger entities that exercise the most effective control over their working conditions. Second, this restriction on how workers and unions can protest is in tension with modern First Amendment case law. Both points are illustrated by a recent NLRB decision in Preferred Building Services. In Preferred, a group of janitors supported by a labor union picketed and passed out literature detailing bad treatment that they had faced at work, including sexual harassment by their supervisor. Naturally, they did this outside of the place they went to work every day. That was an office building managed by a company called Harvest. But Harvest didn't employ the janitors directly. Instead, it contracted with Preferred Building Services, which in turn contracted with a smaller janitorial company called OJS. It was OJS that signed the workers' paychecks, and it was OJS that fired the workers shortly after they sought to draw attention to harassment and the other problems they faced at work. An administrative law judge found that the workers should get their jobs back and other relief, but the NLRB disagreed, concluding that the workers picketing lost NLRA protection because it sought to coerce Harvest or building tenants. To say the least, it is counterintuitive that labor law would not protect workers picketing at their job site to improve fundamental working conditions, such as the right to work free of sexual harassment. But in the modern economy, large companies often contract out parts of their operations, including their janitorial services, sometimes to small firms that work for a small number of clients or maybe just one client. In this scenario, the large companies maintain effective control over wages and working conditions. So if you imagine a small janitorial firm that's squeezed between workers demanding higher pay and a main client demanding lower overhead, I know which side will win every time. Yet labor law expects workers to keep their picketing focused on their small employer and not the large company that employer contracts with. In short, law allows employers to strategically manage their operations through interconnected contractual relationships. It shouldn't then limit how workers respond to the effects of those relationships. Second, the NLRA's prohibition on secondary activity raises serious First Amendment problems. Those problems are especially apparent in recent cases. For example, the board's general counsel's office has recently argued that unions' use of inflatable rats and other animals either qualifies as picketing or is otherwise coercive, and that these balloons violate the NLRA when used for a secondary purpose. In one recent case, the general counsel's office argued that a, quote, huge, menacing, inflatable rat placed near a business entrance inherently conveys a threatening and coercive message that will restrain a person. But even more restrained interpretations of the NLRA's secondary activity ban raise serious First Amendment problems that have only deepened in recent years. The Supreme Court has struck down limits on other forms of protest, including civil rights boycotts, picketing at funerals, and anti-abortion sidewalk counseling. It has increasingly found that legal restrictions on the speech of corporate entities are suspect. Yet the secondary activity ban limits what unions can say on picket signs, ignoring the reality that today union pickets rely on moral persuasion rather than coercion. The PRO Act appropriately responds to these problems by excising limits on secondary and recognitional protest under the NLRA, and it blunts some forms of workplace fishing by adopting a more straightforward and predictable method of distinguishing employees from independent contractors and retaining the current definition of joint employer. Thank you for the opportunity to testify.
Thank you, Ms. Garden. We will now recognize Mr. Alvarez. Welcome, Mr. Alvarez.
Thank you, Chairwoman Wilson and Ranking Member Wahlberg. My name is Josue Alvarez from Bell Gardens, California. I'm 26 years old, and I'm a misclassified truck driver at XPO Logistics. I'm honored to speak with you today about the Protecting the Right to Organize Act. My parents came to the United States from El Salvador in search of a better future. Growing up, my father had many jobs, struggled to make ends meet. We lived in a cramped one-bedroom apartment shared with other families. It was difficult. My dad and I worked for a $15 billion global corporation called XPO Logistics. We know that this company has scams to hide their responsibility to their workers. One scam is calling drivers who own or lease trucks independent contractors, but then controlling them just like any employee. This is known as misclassification. The other scam is completely avoiding any responsibility to a driver who works for them and drives someone else's trucks, usually at the night shift. They call this driver a second seat driver. Whatever they call us, at the end of the day, we're all XPO employees. Where XPO gets away with wage theft and union busting. I didn't always want to be a truck driver. I'm trying to finish my degree in aviation administration, and I have a dream of becoming a pilot, but those dreams are becoming more difficult. I became by that second seat driver in hope that my extra income would not only help my family, but also cover my education. That hasn't been the case. With the income I bring home, I cover costs like cell phone and internet, so my two younger brothers could focus their education. I'm slowly trying to finish my degree, but it's hard when you have to work 14 hours a day and are at the company's mercy. I cannot say now just how much misclassification has badly impacted not just my life, but also the thousands of other misclassified drivers and their families. As a second seat driver, you're paying cash per load. You have no access to benefits. Work nights often receive the worst dispatches. Whenever an issue arises, we bring them to XPO management. They turn us away and tell us that the truck owner is our boss. But XPO controls our work. They dispatch us, telling us when to go and where. And they decide how much we get paid. Controls all relations with customers, including the type of service provided, how much the customer is charged, and the appointments when to pick up the container. My truck says XPO on it. I wear an XPO vest every day. It's clearly who the boss is here. It's XPO. If something happens while we're on the road, we immediately have to report it to dispatch and wait for instructions. One time I was passing through a scale for an inspection. I was issued a citation from DOT and given a report to return to dispatch. This citation falls into XPO since it's their TOT number, but XPO has their own internal point system used to discipline us. For this instance, I received 55 points. Once you hit 75 points, you're terminated. Last year, I purchased my own truck. You may be wondering why, knowing the struggle involved. The answer is that XPO misled me. They told me that they were going to get a bunch of new accounts and work was going to pick up significantly. That ended up not being the case. We haven't seen these new accounts and work has not picked up. Now I'm stuck with this truck. XPO does what it can to fool workers into buying into this business. They try to sell you a dream. My paycheck comes with a statement attached, telling me how much I make per load, and then a list of deduction of insurance and miscellaneous administration fees. I have no idea what some of these administration costs really are, or if they're legitimate. And because I'm misclassified, XPO is able to push operation costs like taxes, diesel, tax, and more into me. My dad and his coworkers tried to organize back in 2015, but XPO misclassification made it impossible to organize. Workers were met with intimidation and retaliation against, and were told that they were independent contractors. An administrative law judge issued her decision, finding us to be employed in 2018. But XPO filed an appeal in the case, and still is still unresolved. The law needs to be changed to be easier to be recognized as an employee. My dad tried to bring me around organizing meetings at first. I wasn't no part of it. I believe XPO and anti-union messaging. I was wrong. XPO is wrong. I realized that things at XPO need to be changed. I don't have health insurance. We don't have sick days or vacation days. We should be able to go to a bargain table and negotiate higher pays and benefits, sick days, vacation days, and grieving procedure. We're not asking for a lot. We're asking for what is just and fair. Being properly classified as an XPO will mean that we could finally form our union or bargain for employee benefits and protection that we have been denied. Our community has been long exploited by this industry, could finally live the middle-class life they came to this country for. My family could finally make ends meet and even thrive. I could finally go back to school and fulfill my dream of becoming a pilot. We could finally achieve the American dream. Thank you. I'm looking forward to your questions.
Thank you so much, Mr. Alvarez. We will now recognize Mr. King.
Thank you, Chair Wilson. Ranking Member Wahlberg, members of the subcommittee, thank you for having me back. Mr. Rowe, nice to see you again. Mrs. Fox, nice to see you. And Committee Chair Scott, nice to see you also. I'm testifying here today on behalf of the Coalition for Democratic Workplace. I am the Senior Labor Employment Counsel for the HR Policy Association, and the association is a member of CDW. CDW represents literally hundreds of thousands of employers throughout the country and millions of workers. The HR Policy Association represents a good number of the major companies in this country and their chief human resource officers. We are opposed to this bill. When I went through it the other evening, I counted at least 30+ negative provisions that are biased, as mentioned by Mr. Wahlberg, toward not only employers but also employees. Also, at least 4 Supreme Court cases are overruled by this legislation. After reading the professor's testimony the other day, I added another one because, as she suggests, secondary boycotts would now be illegal and would be overruled by the Supreme Court decision in question. This is a disturbing act. It amends the National Labor Relations Act to radically change the definition of joint employers. This body recently took the opposite direction. It passed on a bipartisan basis a bill that went exactly the other way and protected small business entities, particularly franchisors and franchisees. I think many people in this country will remember that vote, and this bill clearly is repugnant to what this body did in that legislation. Second, the bill radically changes the definition of employee status under our nation's labor laws and blindly accepts a perhaps California approach known as the ABC test. I would note in passing, even California now is having trouble with this proposal. The General Assembly in Sacramento is not sure how to go. The courts are not sure how to go. They just accepted another remand on this case. This is a bad proposal that will hurt American workers. The bill also mandates that arbitrators decide in initial negotiations, if the parties can't agree, the terms of the agreement, if in fact a majority of employees in the unit have signed cards. This is backdoor card check. This is something this body, as Mr. Wahlberg mentioned, rejected. This is very controversial, not a good idea, not favored by the public, not favored by workers. Further, under this provision, the workers don't even get a chance to vote on whether they would accept or reject what the arbitrators come up with. Not a good idea. Further, the bill, without any premise or predicate whatsoever, would permit intermittent strikes. Why that is a good idea, I have yet to hear anybody give me a good explanation. Intermittent strikes cripple companies and businesses. They're not good for workers. The bill also would overrule, as mentioned, the right-to-work legislation that's been enacted in Michigan, as mentioned by Mr. Wahlberg, and in other states. Let me just give you a practical consequence of that. An employee in one of those states that refuses because of her or his very solid thinking that they do not want to pay fees or dues to a union could be ousted from employment, because in that state now a conditional employment could be made to pay fees or dues. The premise for this bill is wrong. The nation's labor laws are not broken. The National Labor Relations Board is functioning quite well. If you look at the stats I have in my testimony, unions have failed to organize. We're at a 75-year low for petitions being filed in this country by unions. And the stats in the paper speak for themselves. What really is interesting, when you compare the number of potential workers in this country for unionization in the private sector to the number of petitions filed by unions in this country, it's less than 0.1%. Let me emphasize that again. Unions are not devoting any material resources to organizing. Before they come to this body and ask for a lifeline, they should do their own work. They are simply not doing that. That's a startling statistic. And even labor union leaders are criticizing that fact. The AFL-CIO's budget is devoting less and less resources to organizing, but yet they want you to bail them out. Not a good idea. We oppose this bill, and we think it is a very bad proposal, not only for employers, but for employees and for our nation's economy, because it's going to be a formula for disruption. Thank you.
Thank you, Mr. King. We will now recognize Mr. Griffin.
Madam Chair Wilson, Ranking Member Wahlberg, and members of the committee, my name is Richard F. Griffin, Jr. I was the General Counsel of the National Labor Relations Board from November 2013 until the end of October 2017. I want to state at the outset the central importance of workers' rights to join together to form unions and to engage in collective bargaining to any fair economic system. Section 7 of the National Labor Relations Act beautifully articulates these rights, but the rest of the Act does not fulfill Section 7's promise. Reform is needed. I will discuss here the standards for determining independent contractors and joint employers and injunctive relief. Only employees, as statutorily defined, have the right to engage in Section 7 activities. Thus, independent contractors are not protected when they form a union and seek to engage in collective bargaining. When I was General Counsel, the employee status issue and the misclassification of employees occupied a large amount of time and resources for the agency. The status determination requires the application of a complicated 10-part test. The board and the D.C. Circuit disagreed over how to view a worker's potential entrepreneurial opportunity when applying that test, with the board focusing much more on whether entrepreneurial opportunity was actually exercised. Recently, the current board, in the Super Shuttle case, determined that all 10 common law factors have to be examined through the prism of potential economic opportunity. This decision complicates the application of a difficult test, expands the number of workers excluded from the Act's coverage, and opens up the potential for employer manipulation. Employer manipulation resulting in rampant misclassification of employees as independent contractors is a real concern. As an example, we had one case where an employer settled an unfair labor practice charge by agreeing to post a notice advising its truck driver employees of their rights under the Act, only to turn around and advise those same truck drivers that the notice didn't apply to them because they were independent contractors. The PRO Act's 3-part test is easy to apply and will make such misclassification obvious and easily addressable. On the joint employer question, everyone agrees the common law applies. The fight is over what the common law requires. Lost in the rhetoric is the changing nature of the workplace and the need to put employees' representatives at the bargaining table with the entities that have a right to control the employees' conditions of employment. In the modern workplace, the responsibilities formerly performed by one employer are now done by multiple entities. This calls for a particularized application of all the common law factors. The prior board did this in its Browning-Ferris decision. On the other hand, the current board is proposing a rule that would limit the factors considered to possession and actual exercise of substantial, direct, immediate control over the essential terms and conditions of employment of another employer's employees in a manner that is not limited in routine. As an example of why this is a bad test, in a supplier-employer, user-employer situation where a temporary agency supplies permatemps to a workplace, the user supervisors routinely mandate overtime for supplied employees. In contemporary society, where people hold multiple jobs, both spouses are working, commuting distances are great, and child and elder care responsibilities paramount, there are few more essential determinations than whether a worker has to work longer hours on a particular day than she or he planned. In this context, the union representative seeking to bargain voluntary overtime provisions, set schedules, the equitable rotation of overtime, or advance notice of schedule changes has an impossible task if she is limited to seeking such provisions from the supplier employer. In this example, effective collective bargaining requires the user employer to be represented at the bargaining table. The board's Browning-Ferris decision requires consideration of routine, repetitive control, along with indirect control and reserved control. The PRO Act wisely would codify that standard. Finally, on injunctive relief, the Act's critics frequently point to the inadequacy of its remedies. When combined with the requirement to enforce board orders in the courts of appeals, final enforcement comes too late to be effective. The typical worker will think twice about supporting a union if the potential consequence is that she will be fired and have to wait a long time to obtain legal redress. Injunctive relief under Sections 10L and 10J is a powerful way to obtain quick relief. Section 10L requires that that relief be sought mandatorily. 10J is discretionary. Section 10L has been very successful in essentially eliminating the union unfair labor practices, the 8 Bs, that it is addressed to eliminate. Virtually the only time that Section 10L injunctions are sought these days is when general counsels advance novel theories infringing on union First Amendment rights, such as the current initiative seeking injunctions against union symbolic speech using inflatable rats. The PRO Act incorporates mandatory language in Section 10J, making the board more capable of addressing violations quickly and effectively. Thank you for this opportunity to testify, Madam Chair.
Thank you, Mr. Griffin. Under Committee Rule 8A, we will now question witnesses under the 5-minute rule. I will now yield myself 5 minutes. Mr. Alvarez, because XPO Industries misclassified you and other drivers as independent contractors, you're not able to bargain for basic worker protections like health insurance and sick pay. So what happens now when you or a fellow driver becomes sick or needs time off?
We really have to think about it. It's just like any time, it's like if we're trying to take vacation or a day off. XPO still pushes their operation costs into us regardless we go to work or not.
How would organizing a union solve this problem for you and other drivers?
With the union help, we'll be able to go to our bargain table and bargain those benefits that we've been on denied. For example, vacations and sick days. We should be able to go to vacation and not come back to a negative check every time.
Okay, I want to thank you for your courage to testify here today before this committee, and know that we're going to fight for you. We will fight for you and all Americans who want to exercise their rights to negotiate for better pay and working conditions. And thank you for standing up and coming today. Mr. Griffin, I want to thank you for your public service with the NLRB. During your time as General Counsel, you devoted yourself to the core purposes of the National Labor Relations Act, which are to protect workers' freedom of association and promote the practice and procedure of collective bargaining. In your testimony, you detail the harm that misclassification has done to employees like Mr. Alvarez. What are some of the ways that misclassification independently violates workers' rights under the labor law? And how would the PRO Act address this problem?
It's fundamental under the Act. If you are an employee, you have rights. They're protected. If you are an independent contractor, you don't have rights. You're not protected. And so if an employer deliberately takes someone who has employee status and does not allow them to exercise their rights by advising them that they're an independent contractor, that they have no rights, it's a fundamental violation of people's ability to engage in the activities protected under Section 7. In addition, it has a chilling effect on people's ability to speak to each other, to engage in the type of concerted activity that the Act protects because they think they don't have any rights. They're misinformed, misclassified, and it's probably it is an extremely effective way to deny people their rights. And so what the PRO Act does is it takes this 10-part test that's very complicated and confusing and makes it simple and straightforward. And so if somebody misclassifies an employer, it's very obvious under that 3-part test what they've done, and so it makes it simpler to identify the misclassification.
Thank you. Your and this is for Professor Garden. Your testimony details how provisions of the NLRA curtails workers' First Amendment free speech rights. Do the reasons for those restrictions on workers' speech, including the so-called secondary activity as part of the Taft-Hartley Act of 1974, hold up in today's workplace?
Thank you for that question. I think there are two reasons that the reasons behind the secondary boycott provision don't hold up today. One has to do with law, and one has to do with the changing nature of work. First, in 1959, when AB 4 was adopted, and then when it was modified in 1947, when it was adopted and modified in 1959, perhaps Congress could have reasonably seen picket lines as coercive. At the time, refusing to cross a picket line could mean losing the ability to work in a heavily unionized industry. That's no longer the case as a matter of law. Workers' jobs can't be conditioned on their willingness to walk a picket line. That means today's picket lines depend on moral persuasion, not on coercion. Second, work has changed. Fishering situations like the one that gave rise to preferred building services have become more common, and that means there's a greater need for employees to be able to picket outside of the larger entities that control their wages and working conditions as a practical matter.
Okay. In your opinion, should First Amendment rights to free speech be restricted because of who is making the speech?
Absolutely not. And it's not just my opinion, it's the Supreme Court's opinion as well. In recent cases like Sorrell v. IMS Health, even like Citizens United, the Supreme Court has strongly criticized the idea that speech rights can turn on who is speaking at a given time. The court has said that government has to justify speech rights that turn on who the speaker is, and essentially demands proof that the restriction is necessary to achieve an important government interest.
Thank you. Thank you so much. I now recognize the ranking member Wahlberg for his round of questions.
Thank you, Madam Chair. I believe we will recognize the chairman, or the ranking member.
Oh, the esteemed Dr. Fox for her
Thank you,
round of questioning.
Thank you, esteemed Chairwoman. Mr. King, I thank all of the witnesses for being here today. Mr. King, the bill before us today undermines the right of American workers to a secret ballot election to decide union representation. But shockingly, 77 House Democrats who have co-sponsored H.R. 2474, including 12 on this committee, also signed a letter to the Trump administration urging strong enforcement of a new law in Mexico that guarantees Mexican workers that same right to a secret ballot union representation election. Doesn't it seem remarkably inconsistent, even hypocritical, for Democrats to ensure the right to a secret ballot union representation election for Mexican workers, but undermine the same right for American workers? And why is the right to a secret ballot election so important for workers?
Thank you, Dr. Fox. It's nice to see you again. I've been following the United States, Mexico, Canada negotiations quite closely. Our members, many have operations in Mexico. And we are quite concerned about where that's going, but it looks like we have progress. But your point's well taken. Those negotiations guarantee Mexican workers the right to vote on whether they want union representation. And further, it even goes beyond that. The workers in Mexico under the negotiation status at present will also have the right to approve collective bargaining. Their collective bargaining agreement will be subject to a vote. So those rights are even further being articulated and pursued than what's available to American workers.
Thank you, Mr. King. Mr. King, in the first hearing on H.R. 2474, a union leader testifying for the Democrats admitted the reasons they need to force workers to turn over personal information, such as home addresses and cell phone numbers, is so that unions can target workers, quote, at a grocery store, end quote, or, quote, any place else where you can get them, end quote, including, quote, at their home, end quote. Under this bill, would workers have any say regarding the privacy of their personal information and what personal information is shared with the union organizer? What risks, disruptions, or threats could that create for workers and their families?
Well, it certainly could subject them to harassment at any location, as you mentioned, whether it be the grocery store or at their home. And further, there's no ability under this bill for a worker to opt out, to say that she or he does not want to share such information. Additionally, there's no protection whatsoever for this private information. We have all seen the data breaches that occur, particularly in government, but not just in government. So this is a very poor provision. I think members that support this bill will have a very difficult time explaining to their constituents why they authorize the release of personal cell phone numbers, personal home phone numbers, personal email addresses. Very bad idea.
I think there's also some discrepancies in what our colleagues are saying about the internet and agencies that control the internet in this regard. Mr. King, Democrats have made their intentions clear in H.R. 2474 regarding their goal of eliminating independent contractor status, which has encouraged innovations like the sharing economy that millions of Americans embrace and use every day. How exactly would this bill impact business owners, workers, and consumers in the sharing economy?
Well, Dr. Fox, it would eliminate, for all intents and purposes, decades of jurisprudence as to who is and who is not an independent contractor. And as a practical matter, pursuant to your question, it would adversely affect millions of workers who prefer to have a job where they work when they want to work and the independence they have associated with that job. So it's going to hurt that part of our growing economy tremendously. Another very poorly thought out proposal.
Well, our whole country, the capitalist system, is based on the idea that somebody can start a business and get it going and work with other people who are independent contractors. I think it underlines capitalism, frankly. It's a much broader issue, I believe, than what is just in this bill. Madam Chairman, would like to submit for the record an article from the Wall Street Journal, April 30, 2019, called "Big Labor's Big Shrink." Thank you.
Thank you. And now, Mr. Norcross from New Jersey.
Thank you. First of all, thank you for holding the second hearing, because remarkably, facts count. And when we look at the long history of employer-employee relationships in this country, we've had some valleys and some peaks. But the one I look at now is the gap between productivity of a typical worker's compensation and that of their hourly compensation. So as compensation went up pretty much even from the early 60s through the mid-70s with productivity, they stayed pretty much aligned. And I will enter this into the agreement. But then a remarkable thing happened in the mid-70s. Productivity continued to skyrocket, and hourly compensation stayed flat. To the point that they were even in the 70s, there's now a 130% gap over those 45 years. Now you're asking yourself, why? Well, what I heard is Americans are making it today. Absolutely right, if you're that top 1%, which this is what shows. But that's what happened when the laws became outdated and changed for those who wanted to have representation. So now, today, we're left with a set of rules for those who want to collectively bargain that are chiefly stacked against them. You cannot argue with the gap between those who are at the top 1% and those workers. Used to be, if you played by the rules in America and you worked hard, you grew with your company, and they would treat you that way. But what you see today is something that is nothing short of remarkable. Ritz, the Nabisco company in Philadelphia, closing down their shop, moving to Mexico. Why? We do have the greatest workers in the world, but apparently we don't want to pay them, so we ship them off to Mexico and say sorry to everybody else. This has happened time and time again. And then the independent worker, the entrepreneurial spirit. So those Uber drivers are now their own accountant and bookkeeper. They're their tax advisor. They're talking about them as they're now their retirement. They're health advisors to make sure they get the right insurance. They now have to be their legal advisor, their insurance advisor, their safety and OSHA. And these are the same folks that are barely making minimum wage. So what you're seeing is a deferred responsibility, companies dumping it off and making them their own company. We know this isn't going to work. We're seeing evidence of this every day. It's a way of a company deferring their responsibility to making those employees, which, as you spoke, Mr. Griffin, is they have certain rights and responsibility when you're an employee. But when you're a subcontractor, that all goes out the window. So the company hire them now defers all that. Tell me what person you know driving an Uber is his own accountant, his tax advisor, his retirement advisor, health advisor, legal advisor, insurance, and now safety. Tell me how that works. It doesn't. It's not about entrepreneur. Those who want to start their own companies make that determination. Uber drivers don't want to start their own company. They just want to make a fair living. I'm just bringing out Uber. There are dozens and dozens of examples of this. So, Mr. Griffin, in the PRO Act, does this change what would be considered an independent, an entrepreneurial person, and an employee? Could you explain that?
Yeah, I don't think that there's any issue about truly independent contractors who want to start their own business and get customers, as far as those people being limited in their ability to do that. What this test does is it prevents the three-part test that's in the PRO Act. It prevents people who are actually employees, who are not out seeking other customers, but who are handed a piece of paper when they come to work and asked to sign it. That's a paper document that the employer drafts and has a lot of provisions about potential entrepreneurial opportunity that are never actually going to come to fruition, that is designed to misclassify those people. What it does is it puts a very straightforward three-part test to make sure that the person is genuinely an independent contractor. If they aren't, they're an employee.
Well, thank you for that answer. And to enter into the record, the Economic Policy Institute, I ask that this be accepted into the record. Chairman?
Give you another minute.
No, I
You finished? Okay.
just did it.
Thank you.
Thank you.
Without objection. Mr. Wahlberg, requesting.
Thank you, Madam Chairwoman, and thanks to the panel for being here, and some of you coming many, many miles to be here. Thank you. Mr. King, over the years, Congress, I believe, has struck a delicate balance in federal labor law with respect to the interest of employers and workers. During this time, even as the union membership rate has fallen drastically. And we will certainly have, for the record, numbers that will be in stark contrast to some of the statements made about the lack of growth for the average employee during this time. but union membership has, the rate has fallen drastically. The economy has grown enormously, improving the lives of tens of millions of American workers, normal, everyday, blue-collar workers in my district and others. But rather than modernize 70-year-old laws, laws that back, as I mentioned, my father used to organize in steel mill in the 40s, using those laws, the Democrats' current labor agenda would take us back to the volatile 1930s era conflicts between labor and management. Let me ask you this, is H.R. 2474 consistent with the balance that Congress has sought with respect to labor management relations?
Absolutely not. Mr. Wahlberg, it goes just in the opposite direction. It would prohibit an employer from hiring permanent replacements in a strike situation. Now, people say, well, is that fair? The labor laws in this country permit the employer in a strike to continue its operations, not terminate strikers, to replace them so they can continue. Workers can withhold their services and strike. That's a perfect balance. The Supreme Court has approved that. That's been the law for decades. This bill wipes that out. It also, as I mentioned, would permit intermittent strikes. This bill is not well thought out. It's going to lead to instability. It's going to take us back, as you mentioned, decades.
Again, I would say, as I've tried to clearly state in my opening statement, we're talking about union boss control, not necessarily labor, employee control of their lives and their opportunities. So, Mr. King, the decision about whether to unionize is an enormously important question for workers and their families, a decision that they ought to have. But H.R. 2474 codifies the Obama administration's radical ambush election rule, which significantly shortens the amount of time, I mean significantly, the amount of time available to workers to consider the pros and cons of unionizing, from an average of 38 days to as few as 11 days. We don't do that in our efforts here in Congress. We've had more than those days for 2 hearings that we're involved with on this particular issue even. How does the ambush election rule in this bill tilt the playing field in favor of union bosses but against workers?
Unions can take as much time as they want to take to organize. There's no limit. They can engage in organizing activities for years and then file a petition, and per these ambush rules, insist upon an election within, as you mentioned, 12, 14 days. There's not an opportunity for an intelligent dialogue. I remember Senator Kennedy, when we had this discussion quite some time ago, saying at a minimum there should be 30 days before an intelligent, thoughtful discussion. Pros and cons. Workers in this country are bright. They'll figure it out for themselves. But let's have an intelligent period for thoughtful discussion before we have this important vote.
Mr. King, the franchise model has created an accessible path to entrepreneurship for many, many Americans from all walks of life in cities and towns across the country. However, H.R. 2474 codifies the Obama LNRB's joint employer standard, which would essentially turn independent franchises into middle managers. That's not what they got into the franchise for. They wanted their own business, and local small business employees into employees of faraway corporations. What impact would this have on entrepreneurial opportunity and on the employees of the enterprise? And also, what might union leaders and trial lawyers prefer, or why might they prefer the Democrats' joint employer standard?
This bill will have a very negative impact on franchisees, small business entities. There are hundreds of thousands of these startup and successful business entities in every community. Subjecting them to litigation and uncertainty is going to chill the opportunity for them to continue, and certainly chill the opportunity for growth in this area. The only people that benefit from this proposal in H.R. 2474 with respect to independent contractor and joint employer are trial lawyers and some law professors that can write articles about the complexities, as Mr. Griffin mentioned, of this law. It is a terrible idea. As I mentioned in my opening statement, this body rejected that approach and passed a bipartisan proposal that's much fairer, much more even-handed. That's where we should go.
Thank you. I'm over time. I yield back.
We'll now hear from Ms. Weil of Pennsylvania.
Thank you, Madam Chairwoman. Thank you to all of you for being here to testify on this very important subject, and in particular, Mr. Alvarez, I'd like to thank you for being here today. I assume you were missing a day of pay to be here, is that correct?
Yes.
You're only paid when you are working, driving. Is that fair to say?
Yeah, that's correct.
I have grave concerns about the misclassification of your status with XPO Logistics, which happens to have a significant presence in my district in Pennsylvania. And I also want to thank the Teamsters and the presence of labor here in our committee room. I'm sure they would welcome you, Mr. Alvarez, as a member if you were able to collectively bargain, but you're not able to, is that right?
That's correct.
You don't have that ability because you're classified as an independent contractor. And under the National Labor Relations Act, independent contractors have no rights to organize or collectively bargain. Isn't that right?
Yes.
And I don't have enough time here today to go through the criteria for an independent contractor versus an employee, but I just want to highlight some of the things that you presented in both your oral testimony and your written testimony, ways that you've told us that XPO dictates your manner of work. And let me just reinforce, XPO characterizes you, classifies you as an independent contractor, notwithstanding the fact that they control all the relations with the customer. Is that true?
Yeah, that's correct.
They get the customer, they determine the service that's going to be provided, they negotiate the price, and they schedule the pickup. True?
Yes.
The truck that you now own has XPO painted on it. True?
Yes.
And you wear a vest when you are driving that says XPO on it. True?
I have it right on with me right now.
That's what you're wearing now?
Yes.
And it does not say Alvarez Trucking, nor could you wear a vest that said that, could you?
It doesn't say Alvarez Trucking, it says XP on it.
And if you were to call your business, quote unquote, Alvarez Trucking, you would not be eligible to drive for XPO. Is that true?
That's correct.
And if you don't get enough work from XPO, you can't go solicit another load from some other company, can you?
No, our contract will be terminated.
Thank you, Mr. Alvarez. So let me ask all of the witnesses, is there anybody here who disagrees that companies have an economic incentive to classify individuals as independent contractors rather than employees?
I disagree with that.
You disagree with that, Mr. King?
Yes.
I'm not surprised that you do. And you believe that there is no economic incentive for an employer or for a company such as XPO to classify their employees as independent contractors?
We did a study of our members, most of the largest businesses in this country. Their number one reason for subcontracting or outsourcing was efficiency, productivity, and quality. Only 2% mentioned any avoidance of the labor laws. This is a wrong premise.
And those members, Mr. King, are exactly the entities that are classifying their employees as independent contractors, correct?
Those 2%, perhaps. And are we going to write legislation to penalize the rest of the country for a few rogue employers? I think not.
So, Mr. King, I assume that you agree with the recent NLRB decision in the Super Shuttle case that creates a situation where workers will be considered independent contractors if an analysis is done that says that the worker has an entrepreneurial opportunity.
Not only do I agree, but the U.S. District Court for the District of Columbia agrees. The courts
I'm just
agree.
asking you if you agree.
Yes, I agree.
That's
Yes, I do
your.
agree.
So you believe then that Mr. Alvarez here has an entrepreneurial opportunity in driving for XPO?
Well, I looked at the facts of that case, and in all due respect to Mr. Alvarez, they're much more complicated than what you have been shared with this morning.
In fact, in the Super Shuttle case, many of those drivers for Super Shuttle were actually subject to non-compete clauses that prohibited them from pursuing entrepreneurial opportunities at other companies, correct?
There was an element of that. The non-compete issue is a wholly different issue. I would be happy to discuss that with you.
Well, wouldn't you agree with me that an entrepreneur should have the opportunity to compete in any possible way? I mean, my colleague, Mrs. Fox, talked about that being the American spirit of competition, and yet the drivers in the Super Shuttle case aren't allowed to compete.
Well, they're not allowed to compete in certain areas. When we talk about competition, that's a wide-ranging word. So we need
Thank you, my time is up.
Go ahead. Now we'll hear from the esteemed Dr. Rowe.
Thank you, Madam Chair, and thank all the panelists for being here today. And I want to say, to start out with, that this is the best economy in my lifetime. It's good to see Mr. Griffin and Mr. King again.
Thank you.
I do want to say just a couple of things before I get started. I think one of the most important things in this free society that we live in is the secret ballot. I put a uniform on and left this country 46 years ago to serve in Southeast Asia to be sure that you had a right to vote how you wanted to. And I say this as a joke. I think my wife votes for me every time I run, but it's a secret ballot, so I don't know for sure. She says she does, but I'm not sure that she does. So why shouldn't that's how we're elected, how the president's elected, how every legislature's elected, how union representatives are elected. People voting for the union should absolutely have a right to a secret ballot, period. Number two, on the sharing of private personal information. As a physician, I tied myself in a knot with HIPAA, being sure that I protected all of that information. It was very private, and patients could release whatever they wanted to. You should be able to do the same thing. Thirdly, on right-to-work laws, look, it's a right. I grew up in a union household. My dad was in the United Rubber Workers Union. He was a factory worker and made shoe heels for B.F. Goodrich Company until he lost his job to Mexico. Right now, fortunately, those manufacturing jobs are coming back to the U.S., and that's a very good thing for union workers, and we should approve this USMCA. And I agree with my Democratic friends who insisted that Mexican workers could have a secret ballot protection. I agree with that. That was a right and proper thing that they did. I want to share with you just very quick, and by the way, there are 7.4 million unfilled jobs. I had a truck driver walk up to me in a Wendy's the other day in Dandridge, Tennessee, and he said, listen, this is the best of my lifetime. I made $164,000 driving a truck last year. I have 2 trucking companies in my district. Both of them are begging for truck drivers. They have, and when the president said he was going to block the Mexican border, this trucking company went berserk, and not because of the lost business. They were afraid they'd lose their drivers. It's 700 and something drivers, and the most valuable thing in that business were their drivers, their personnel. When I served as chairman of the Help Subcommittee in 2015, we heard testimony about the effects of the Obama-era Browning-Ferris joint employer status from Mr. Ed Brady, who owns a Burger King in inner-city Baltimore. And all the men that Mr. Brady hired at that store had a run-in with a criminal justice system. All the women he hired had been on some form of government assistance, and he hired people to give them an opportunity at a better life, as he described it. This ambiguous standard were implemented as the PRO Act would do. The Burger King Corporation would be liable for many of the hiring decisions that were made by Mr. Brady. Why would we expect any corporation to know a community better than someone local like Mr. Brady? Wouldn't a corporate entity be more risk averse and less likely to give people a second chance, Mr. King?
That's part of the problem. It's not the major problem. How can a local business owner, Dr. Rowe, like you described, go through this complex litigation scenario that could put them out of business? This bill is designed from our perspective to chill the rights of employers, particularly small employers, small business entities, faced with potential fines for the first time in the history of the National Labor Relations Act, faced with the imposition of unionization. This is a backdoor card check bill. It will have a potential devastating impact upon the small employers as a practical matter.
Mr. King, wouldn't codifying the ABC test and the Obama NLRB joint employer standard at the federal level essentially eliminate the entire franchise industry as we know it, which employs more than 7 million Americans nationwide, including 21,000 in Chairman Scott's district?
I think the answer is yes. And the reason for that is, look what's happening in California, Dr. Rowe. As I mentioned, the California legislature now is reconsidering this entire ABC test. The courts out there are reconsidering it. There's a considerable amount of tension back and forth. The legislative body in California has had to carve out exceptions already just to have a discussion about this approach. It is a very poor approach, and it should be rejected.
I'm going to finish because my time's almost expired and has expired, and I want to thank those folks sitting out there that have their Teamster shirts on. That's a community I grew up in. I appreciate the hard work you do. And as I said, every American has a right. If they want to organize, they should be able to do that. If they don't, they should also have that right. I yield back.
Thank you. And now, the distinguished chair of the Ed and Labor Committee, Mr. Scott, your questions.
Thank you, Madam Chair. Mr. King, you indicated in your testimony that there are several provisions that would overturn Supreme Court decisions. Could you list those and state whether or not the Supreme Court ruling was based on statutory interpretation or constitutional right?
Well, I list them, Mr. Scott, in footnote 1, the Epic Systems case, the Hoffman Plastic case, McKay Radio case, and I've added, after reading, as I mentioned, Professor Garden's testimony, the Retail Store Employees Union local case, that's the secondary boycott case. All of those cases, from my perspective, thoughtfully reviewed the statutes in question and arrived at the right decision.
So if it was based on constitutional right, you couldn't overturn it with a statute. If it's based on statutory interpretation, a new act would be okay. It's constitutionally okay.
Well, certainly from a policy perspective, we wouldn't think it would be okay, but I understand your question.
Thank you. Ms. Gardner, if a person is hired by a temp agency and placed at a work site, could you say what the implications of joint employer would be and secondary boycott if there was a picket?
Absolutely. The first question would be whether the National Labor Relations Board would agree that the work site was the joint employer of these employees. The Browning-Ferris test makes that determination more predictable by allowing reserved or indirect control to be part of the consideration. So if you instead required substantial direct actual control, then you could have a scenario in which the job site has reserved but not yet exercised control. 1 week, another week, they start to exercise control, and you would have that entity shifting from being not a joint employer to a joint employer. So the Browning-Ferris test is sort of easier to tell at the outset and more stable in terms of whether or not somebody is jointly employed.
And if they are not a joint employer, you can't negotiate, you don't have a right to negotiate with them even though they effectively set the salary by virtue of the contract with the temp agency.
That's exactly right. And as the preferred case shows, workers who attempt to influence what the work site pays them and how it treats them face the sort of very dangerous waters of negotiating what they can and can't say, how they can and can't protest under Section 8B4.
And how does the secondary boycott issue apply to that case, to that situation?
So in preferred building services, there were sort of two issues that the NLRB talked about. One was whether the workers were in what's known as the Moore dry dock set of presumptions. Moore dry dock provides a carve-out for workers to engage in some secondary activity, including picketing, at a job site as long as they meet some fairly detailed requirements. The board found that the workers lost the benefit of that presumption, in part because they distributed handbills that called on building tenants to try to influence the condition of, quote, their janitors. That choice of pronoun, right, their janitors, seems to me to say the janitors who clean your office. Apparently the board saw it differently as janitors you employ. Whatever you think of those two possible interpretations, it is hard to tell in advance what a board is going to do and whether or not you are going to retain the protections of the National Labor Relations Act if you're fired as a result of your picketing.
Thank you. Mr. Griffin, one of the provisions of the bill allows, excuse me, allows the imposition of meaningful sanctions. Can you say why the sanctions in present law are not sufficient and why sanctions such as back pay without reduction based on interim earnings are insufficient?
Yes, currently, the rule, the general rule, if someone is discharged, is that the remedy is back pay minus interim earnings and reinstatement. Generally speaking, because of the time that it takes to go through the process and because of the hostility that's been generated as a result of the discharge, the person is likely or will be offered to waive reinstatement as part of the resolution, so they won't go back to work, number one. Number two, they have an obligation to mitigate their damages, and because most people who work for a living work paycheck to paycheck, they have to do that, and that work for another employer is counted against the money that is owed to them, so that it is not a very serious deterrent to an employer who discharges someone unlawfully that they have to pay that difference between what they make as they seek employment elsewhere. So making sure that people are actually paid for the results of the or actually get paid, and the employer has to pay
Mr. Griffin,
for their
time is up.
Oh, my apologies.
Thank you
Madam
very much. Mr. Taylor?
Thank you, Madam Chair. Appreciate this hearing. Thanks to the witnesses. Mr. King, I just wanted to follow up with Dr. Rowe's question earlier about ABC in California. As a state legislator in Texas, I certainly saw over and over again the number of new businesses coming to Texas that talked about one of the reasons they're relocating is because it's a right-to-work state. And we have certainly been very successful in our job creation in Texas as companies leave union states to come to a right-to-work state. I'm very blessed to wake up in a city, Plano, Texas, that's the highest per capita income city in North America with over 250,000 people. So clearly we have been successful in creating high-income jobs in a right-to-work state. And clearly one of the benefits of America is we've got 50 states. We have a laboratory of democracy. We're watching California go through the ABC test. Would you mind just, and since HR 2474 has the ABC test word for word in it, and it has not yet been adopted, as I understand, by the state of California, could you take us through what that does and how it works?
Certainly be happy to do so. The second prong of the test is the one that you should focus on. It states that you cannot be an independent contractor if you provide services that are within the scope of the hiring company. That, by and large, makes virtually anyone that would perform a service for a hiring company, a user company, if you will, an employee. That is very controversial. The other two parts of the test would also have to be satisfied, but really the focus has been on prong 2. Let's just think about that for a minute. A hospital, for example, that brings in individuals that are at a nursing agency because they have a high census of patients. Those agency nurses under the second prong of that test would be employees, not independent contractors. That's never been the law. That makes no sense. And this whole premise that somehow employers are using independent contractors to evade the law, per the colloquy we just had, is incorrect. It's not based on fact. Yes, there may be some rogue employers out there. They should be brought to justice if they're misclassifying individuals. We don't support that. But this economy we have that's doing so well is based on so many different relationships every day. Even the smallest business brings in independent contractors to do a variety of things. They do so for efficiency reasons, productivity reasons. Yes, they do control costs. So the California legislature is starting to see this. We'll see where that goes. But no matter what California does, I would submit to you that's not a good way to run our country. The laws in California are some of the absolute worst for employers, And many employers that I've worked with over the years as a lawyer exit that state for that very reason.
Sure, and just to build on that, in my time in Collin County, I've seen many employers use 1099 contractors to take on a particular project. Hey, we're going to develop, and particularly in the IT space, we have a lot of IT companies there. Hey, we're going to build a website, we're going to build an MIS system. It's a 6-month project, it's a 1-year project. We're going to bring in some 1099 contractors so we can have greater control over what we're actually doing, rather than bringing in a consulting firm that is sort of doing it off-site. They can do it on-site with 1099 contractors, and that's been very successful for them. And we have a lot of extremely well-paid people who are 1099 contractors who have a very good lifestyle in Collin County, running, doing different MIS projects for different employers. And it seems like what you're saying is that this would end that. That at least my community, if 2474 became law, that ability of the employers that I have in my district they wouldn't be able to do that anymore. The ability to use 1099 contractors for specific projects, those people to work as 1099 contractors, which is what they want to do, that goes away. Is that what you're saying?
Absolutely, would either stop it or lead to litigation and regulatory interference. And that is another dead end for that kind of economic growth.
Yeah, this is an unfortunate, because I think to have a successful economy, you need to have a sophisticated way to be able to organize, and clearly we have that now, and this really takes away a whole series of tools that businesses are using with great success to the benefit of the businesses and to the employees who are working and who I have the privilege to represent here in Congress.
Yeah, absolutely, and many individuals prefer to be independent contractors, frankly.
Yeah, absolutely. Thank you, Madam Chair. I yield back.
Thank you. Ms. Macbeth of Georgia.
Thank you, Madam Chair, and thank you for each and every one of you that are here giving your testimony today. I'm committed to truly protecting the rights of workers throughout this country while also being mindful of the effect of these laws on small businesses. I have a lot of small businesses within my district. I do not believe that the two are mutually exclusive. Workers' protections make for better, more productive employees and better business. I do, however, have concerns with actions taken by this administration and the adverse effects that they could leave on employees and small business owners. Mr. Griffin, the question of whether a worker is an employee has historically been kind of governed by the common law of agency. The Trump NLRB issued the Super Shuttle decision on January 25th, 2019, holding that they would apply the common law test, and I'm quoting, through the prism of whether the worker has entrepreneurial opportunity. Moreover, in that matter, the board maintained the drivers in that case were independent contractors, even though they had been required to sign non-compete agreements. First, can you speak to an agreed-upon definition of entrepreneurial opportunity? How would you define it, and what legal significance does it hold?
Well, if I may, the controversy over entrepreneurial opportunity between the former board and the D.C. Circuit and the current board's decision really turns on whether or not it's a speculative, hypothetical opportunity that's never likely to come to fruition, or whether there's evidence that the entrepreneurial opportunity has actually been exercised. And so the board, in its dispute with the D.C. Circuit in the FedEx cases, it did not say entrepreneurial opportunity shouldn't be considered. It said it should be real exercise, actual evidence, as opposed to hypothetical, speculative, paper documentation of potential opportunity never to be realized. And one of the reasons this is important is that most of these instances that result in these kind of cases are not instances where an independent contractor comes in and negotiates with the customer the terms of the provision of service. Rather, somebody shows up to do a job, they are handed a document that's entirely drafted by the employer that has a bunch of provisions that talk about potential entrepreneurial opportunity, so they can paper up the independent contractor theory, when in fact there's absolutely no evidence that that opportunity is actually going to be exercised. And If the opportunity is going to be exercised and has been exercised and there's evidence of that, then that's a legitimate factor to be considered. But this kind of paper speculative hypothetical business is not really worthy of consideration, in my opinion.
Okay, and let me ask you also, how can a worker exercise meaningful entrepreneurial opportunity while being prohibited from engaging in competition?
I think the short answer to that is they can't. The notion that you're an entrepreneur but you can't compete, you can't go out and get other jobs, you have to work for this employer, would seem to demonstrate, at least fairly strongly, that you're actually an employee of that employer, not an independent contractor, not an independent business person, not capable of going out, bidding on other jobs, getting other work, seeking other customers.
On June 28, 2019, the New York Times reported that within the 600-page-long disclosure document given to prospective Subway franchisees, that the franchisor reserves the right to revise its rules at any time during the term of franchise agreement, and that it can make changes under any condition and to any extent. Subway franchisees could face harm by the overwhelming control exercised by their franchisor. If the Trump NLRB succeeds in narrowing the joint employer standard, wouldn't that risk giving the franchisor more control over franchisees' employees' terms and conditions of work, while leaving franchisees on the hook for any violations of law directed by the franchisor?
Yes, what the franchisors in this context want is to have their cake and eat it too. They want to be able to control terms and conditions of employment, but have no responsibility. The franchisee is always going to be the employer. The question is whether, if the franchisor engages in certain co-determination of wages and terms and conditions of employment, whether they also will be responsible for bargaining and for unfair labor practices. So to the extent that you narrow the joint employer definition, you leave the small business, the franchisee, holding the bag entirely, and you allow the joint employer franchisor to escape liability.
Thank you, and I yield back to the remainder of my time.
Mr. Wright of Texas.
Thank you. Thank all of you for being here. Mr. King, and I represent most of Arlington, Texas. And as most people know, Texans love trucks and freedom, not necessarily in that order. And they're in abundance in Arlington because the largest employer is a General Motors assembly plant, employs over 4,000 people, good paying union jobs. 15 minutes up the road is Dallas-Fort Worth International Airport, one of the largest in the country, again, with a lot of good paying union jobs. So Arlington is an excellent example of a place where unions not only exist but thrive in a right-to-work state. Now, we hear from my friends on the other side that right-to-work laws giving workers the freedom to decide for themselves whether to join and pay a union somehow undermines the right to organize. That would not seem to be the case in Texas, but does giving workers this freedom of choice in any way change the process, the union organizing process?
Well, I think it certainly does, Mr. Wright. What this bill does, as you know, is prohibit states like Texas from having a right-to-work law. And that, in and of itself, is a major problem. Further, the unions can continue to organize in right-to-work states, as you mentioned, and have done so with success. Again, this approach in 2474 is simply a bailout for organized labor in other areas. And let me just bear in on this right-to-work issue. If this bill passes in your state, an individual that right now has decided, for whatever reason, that she or he does not want to pay union dues or fees could be subject to termination if the employer and the union insist that that fee payment or dues payment be a condition of employment. So what you will be doing with this legislation, if it passes, is putting people out of work that have strongly held convictions. And back to your point, shouldn't individuals have a right to choose for themselves?
That, in fact, is one of the reasons that Texas has one of the best economies in the country and why it is one of the fastest growing states, why people from other states are moving there, companies from other states are moving there. That's one of the reasons. But in your experience, there is no evidence at all, is there, that right-to-work laws somehow undermine the right to organize?
No, not at all, Mr. Wright. In fact, you can make an argument just the opposite way, that when you have an organizing campaign and the right-to-work option is available, some employees may say, well, I might even vote for the union because I won't have to pay fees or dues. It can be used against employer and organizing campaigns, and I've seen it. So there's no correlation whatsoever. The lack of union density in this country, as I point out in my testimony, is right back at the union movement. They have not invested the resources or the time, and the facts bear that out. We are at a 75-year low, I believe, regarding the number of petitions filed by unions in this country. And as the testimony points out, less than 0.1% of the eligible workers in this country were petitioned for last year by organized labor. That's not a story that should be a predicate to support this legislation.
Okay. Let me shift very quickly to franchises. You mentioned it in your opening statement, Mr. Griffin just mentioned it a moment ago. Can you elaborate a little bit on the obstacles to even starting a franchise that are presented by this bill?
Of course, there's the capital, and then there's a support, whether it be in bookkeeping, legal, structure, what have you. And it's interesting to hear this discussion because small business owners don't want to be embroiled in this kind of litigation. They don't want to be brought into Fair Labor Standards Act or National Labor Relations Act litigation. They want to run their business. And the franchisors that I know and work with, they want no part of the day-to-day operation of that business, the direct control. I was interested in Mr. Griffin's comment. He's looking for some type of direct control in the independent contractor area, but I don't think that's where he goes on joint employer. What we're saying on joint employer, there ought to be direct and immediate involvement in the day-to-day business before anyone is a joint employer. So these franchisees that are small business people are trying to start a business. They need help, obviously, from the franchisor, but the reputational integrity of the brand, training, and auxiliary things should be furnished. But with these kind of laws, you're going to chill that development, and that's bad for our economy, bad for your community, bad for everybody involved in this discussion.
I would agree, and I yield back. Thank you.
Thank you, Mr. Wright. Mr. Levin, Michigan.
Thank you so much, Madam Chairwoman, and thanks for having this very important hearing. I want to ask a question of Ms. Garden, but before I get into that, I want to say a couple things. Mr. Alvarez, we will get justice for you. However long it takes, we will get justice for you and other workers who are denied your freedom of association because of these laws. I just want to tell you that.
Thank you very much.
And thanks for coming here. Mr. King, I'm just making a comment, but you can turn your mic on if you want. I am disappointed that you would mischaracterize the position of someone who's no longer with us. Mr. Kennedy was the original sponsor of the Employee Free Choice Act in the Senate, as you well know, a bill that would do away with the situation where workers have to have an election against their boss just to decide to have a union at work. And he was a champion of workers' freedom to form unions without that American innovation. And so I don't really appreciate his name being used to oppose that policy.
Well, if I may,
no, I'm not asking you to respond. And,
I worked with Senator Kennedy for many years on the
Sir,
Senate side.
I'm not yielding you time. And I want to remind my friend, Mr. Taylor from Texas, who spoke about high wages due to the right to freeload laws there. Texas is about in the middle, according to BLS data from 2016, $17.06 hourly wage for median wages. Not one of the top 10 states in these United States is a right to freeload state. They're all states with high levels of union representation, and none of them have right to freeload laws. Ms. Garden, this committee has expressed a lot of interest in the future of work. And it's especially interesting to us how that relates to protecting workers' rights amid technological change. the rise of the gig economy, more complex contracting arrangements, which have been used purposefully by very smart people like Mr. King to keep workers from forming unions. How does protecting workers' First Amendment rights, in particular, help them to adapt to the changes we're going through in the economy and protect their right to secure better working conditions?
So as work evolves and the nature of work changes, we sometimes find ourselves in situations where the law has not yet caught up to those changes. And when that's true, workers are on their own. Sometimes their best, most immediate recourse involves exercising their First Amendment rights, right? Their First Amendment right to engage in picketing, their rights to engage in collective action, in order to try to get better treatment from the organizations that are controlling their day-to-day lives and their ability to put food on the table.
So let me ask you about a particular case. In 2012, Walmart workers without a union and collective bargaining in 100 cities across 46 states participated in short strikes and peaceful protests to fight for better wages and working conditions. These protests did not prohibit anyone from entering a store or did not interfere with the operation of the facilities and had really zero potential to force a union on reluctant employers or workers. Nonetheless, workers who participated were threatened with penalties under Section 8B7 of the NLRA after Walmart alleged that they were picketing in an effort to force Walmart to recognize the union. Unfortunately, modern legal doctrine prevents workers from peacefully picketing their employer to encourage recognition of their union. How is the current legal precedent interpreting Section 8B7 of the NLRA misconstrued congressional intent behind the Taft-Hartley Amendment?
Great. Thanks for that question. So 8B7 was aimed at so-called blackmail picketing, prolonged shutdowns of workplaces aimed at forcing an employer to accept union representation for employees, regardless of what those employees wanted. That could not be further from a situation like the one you described, where unions picket a store that continues to operate, demanding better treatment for workers. That a complaint in a situation like that could gain a toehold shows how far the law has drifted from the blackmail picketing that Congress was worried about.
Thank you so much. Madam Chairwoman, I just want to say to my dear friend, the ranking member from our great state of Michigan, he spoke about the delicate balance that's been created over the decades. The Wagner Act was passed in 1935. There has not been one sentence of federal law added by this Congress since then that helps workers be free to form unions and bargain collectively. The Taft-Hartley amendments in 1947 and the Griffin amendments eroded workers' power through their own organizations, and it's high time that this Congress free up workers in this country just to have a union and a better say at work. We will not deal with income and wealth inequality in this country until we do that. Thank you, and I yield back.
Thank you. Mr. Muser, Pennsylvania.
Thank you, Madam Chairwoman. Thank you all very much for being here with us. I am a former business company president, business owner. I, like many, have many good businesses, small businesses throughout my district. Many are union, many are non-union. I am entirely for, my reason for being here is to help grow, help businesses grow, help family incomes grow, participate in actions to create environments for wage growth, for union and non-union, low unemployment, and just to fight for people and represent their overall interests in our economy. So, but there are some concerning points within this bill. I'd like to talk about privacy a little bit, and in the bill, the requirement for access to employees' personal data without consent. I don't really necessarily understand the value there. So, Mr. King, allow me to ask you, what are the dangers, what are the reasons for such a provision to be in this bill?
Apparently, The rationale is for access of unions to contact potential voters in a union election. In reality, there is no ability for the employee to opt out, to say that she or he does not want personal information to be shared. There is no protection whatsoever, even if that information is furnished, to not have that information be a data breach or shared with third parties. In this day and age, the union movement has any number of opportunities through social media and other ways to contact potential voters. This is a desperation move, it would appear, on behalf of organized labor. There is no rationale for it, and it is a bad idea.
Right. And, like many here, I was at the tail end of my business career, served as president of a company, but I was a driver, I was a builder, I was a credit collector, I was in sales, I was in marketing, I was in, operations. So you during the course of that, you become conditioned to appreciate the needs of all workers, everyone. Everyone just has different titles and different responsibilities, but you're all part of the same team. And that's why I also question, why is it when we had the USMCA discussion, an issue arose where in Mexico, the management were the ones against the secret ballot, yet here, the union leadership is against the secret ballot. Mr. King, could you offer your opinion on that?
It's hard to reconcile. The USMCA negotiations hopefully will result in approval by this body, but contained in those discussions is the right of the Mexican worker to vote on whether she or he wants to be represented. And as I mentioned earlier, in addition, whether the contract that's being proposed by the Mexican labor union should be accepted. It's really very contradictory. We have this bill that will cut off rights of employees to vote and forced unionization, but just the opposite south of the border.
All right, thank you. I'm going to yield the remainder of my time to Mr. Wahlberg.
I thank the gentleman, and a lot of things I would like, Mr. King, to allow you to respond to, especially relative to Senator Kennedy and the assertions there. But let me ask you this one question. Under current law, union organizers can make death threats and commit acts of violence free of legal repercussions so long as these actions are taken in the pursuit of, quote, legitimate union objectives. Why is this the case, and would H.R. 2474 change the law relative to this?
Unfortunately not. That type of rogue activity would still be permitted. And Mr. Alvarez, what's interesting, the fines that are suggested in this, not suggested, proposed in this legislation, up to $100,000, only apply to the employer. Unions are not subject to any of the fines for misconduct that are articulated in this legislation. That makes no sense whatsoever. You talk about bias. That's one of the prime examples of this bill. It's only directed at employers. But that strike misconduct still could occur.
Which does not encourage unionization. I think the beauty of the fact of the numbers going down is the fact that unions have done some great things, and it's gotten better. So thanks for responding.
May I, Mr. Wahlberg,
Thank you.
I take personal offense of what was just said. I worked with Senator Kennedy when I was...
Your time is up, sir. You have no
I
time.
yield back.
I recognize Mr. Courtney from Connecticut.
Thank you, Madam Chairwoman, and thank you to all the witnesses for being here today. Mr. Griffin, on page 9 of your testimony, you again dove into what I think is accurately described as there is no more controversial issue than the joint employer rule and the Browning-Ferris decision. We've had numerous hearings over the years on this committee, and I'd like to just spend a moment on that issue with you. So in 2015, Browning-Ferris decision found that a company can be a joint employer if it has contractual control or exercises indirect control over another company's terms and conditions of work. This decision was essential to workers who are increasingly hired by staffing agencies and subcontractors performing work for a company that often controls working conditions while evading liability. Browning-Ferris was case was pending review at the D.C. Circuit when the Trump NLRB began its rulemaking to overturn Browning-Ferris, but the D.C. Circuit issued its decision last December. In that decision, it explicitly upheld the Browning-Ferris standard, and it also noted that the question is actually governed by common law, which is not, again, confined to indicia of direct and immediate control as the NLRB under the Trump administration was seeking to do. And it also urged the NLRB against taking the first bite of an apple that is outside of its orchard. So if the current rulemaking is likely at odds with the D.C. Circuit, isn't the board wasting time and resources that could be better used elsewhere?
I think it is. Thank you for the question. First of all, as you noted, the joint employer question is the common law standard is applied. And typically and historically, the common law is something that develops in a process of case-by-case adjudication, and rules emerge based on review of multiple cases. And it's very odd to decide to do a rulemaking proceeding where what you're trying to address is a common law standard. It doesn't comport with the notion of the common law, number one. Number two, the D.C. Circuit said in its decision that the board gets no deference. Administrative agencies under the Chevron doctrine get a certain amount of deference under certain circumstances with respect to their decision. And the D.C. Circuit said, well, as to the common law, that's not the statute, that's the common law. You get no deference to that. And the D.C. Circuit interpreted the common law to include a number of factors that the rulemaking process so far discounts. Indirect, reserved control, routine and regular exercise of authority. And rulemaking is prospective. The board has a backlog of cases, people who are hurting, who have allegations of unfair labor practices against them that are waiting decision. The board should be deciding those cases and not spending an effort, contrary to what the D.C. Circuit said, on a prospective exercise.
Thank you. And I think, again, in terms of just judicial review, obviously, the D.C. Circuit trumps, to use a bad pun, the NLRB in terms of a settled issue. Again, just real quickly, the PRO Act obviously touches on this issue, and I mean that hopefully would bring total clarity in terms of just the definition of the joint employer rule. Is that right?
Well, what the PRO Act would do would essentially codify the Browning-Ferris interpretation of the common law factors. Yes.
Thank you. And again, I think, as I said, we've wasted or spent a lot of time on this issue. And again, if the common law is organically moving in a direction that the D.C. Circuit embraced, I mean, I think, frankly, we should join them in that effort as well with passage of this law. Again, my remaining time, I just want to thank Mr. Alvarez for being here today and putting a human face on this issue. This is not sort of just a political who's up, who's down, horse race kind of issue. This affects real people in real lives. And again, thank you for being here today to really, spotlight that. And with that, I yield back.
Thank you, Mr. Courtney. Mr. Allen of Georgia.
Thank you, Chairwoman. And Mr. King, would you like to finish your comments regarding our Senator Kennedy?
Thank you. Thank you for your courtesy. Senator John Kennedy did, in fact, support the 30-day period between the petition filing and the election, and we'll submit that for the record. The second point I wanted to make is that I worked in the Senate with the Senate Help Committee many years ago and had the pleasure of working with Senator Ted Kennedy, including the time he was chair. My patronage was Senator Robert Taft. Senators Taft and Javits and Kennedy worked together. So I do have a strong admiration for the Kennedy family. Thank you for your courtesy.
Sure. Mr. King, Georgia is a right-to-work state. We have been named the best state to do business in the last 6 years to locate your business. A lot of reasons for that. Obviously, the skilled workforce is usually number one. So workers have a choice in Georgia. But it was interesting, just this week, the presidential campaign of a leading socialist Democrat, a co-sponsor of the Senate version of H.R. 2474, was hit with an unfair labor practice charge for recommending a pay raise amidst collective bargaining negotiations. If this situation occurred with H.R. 2474 signed into law and the charge were upheld, could Senator Sanders' presidential campaign be assessed a civil penalty costing tens of thousands of dollars simply for trying to reward its employees with a pay raise?
Certainly, Mr. Allen, that would be a distinct possibility. And I think this goes to show that our nation's labor laws are effective. They do work. They are alive. They are well. And even someone at that level in our political system has to abide by them.
The workplace changes. In fact, the business world changes because of e-commerce, and just everything moves rapidly. And so does the workplace. The workplace looks much different than it did years ago, and so do benefits, so on and so forth. Much of what the unions fought for has been codified into law, eliminating issues from consideration in collective bargaining. One of the things unions still pride themselves on are health care plans that they negotiate for their workers. But a Democrat member of this committee has introduced legislation co-sponsored by nearly 120 House Democrats to ban private health insurance, including union plans, and force every American onto government-run health care. How might banning union health care plans and a government takeover affect the value of unions for workers?
This is another very poorly thought out idea. The HR Policy Association, where I am counsel, works closely with our member companies, and we have found consistently that employer-sponsored health plans are popular and are very much desired by the employees. And I believe, as someone said recently, if you turn anything over to the government, totally you have issues. And that's exactly where we would be headed. So I can say on behalf of the HR Policy Association and its member companies and their employees, we should continue the highly favorable and well-received employer-sponsored health care plans in this country.
And then finally, with the remaining time, union allies insist that right-to-work laws giving workers the freedom to decide for themselves whether to join and pay a union undermine the right to organize. Does giving workers this freedom of choice in any way change the union organizing process?
I have not seen any data, Congressman, that would connect the two thoughts. I don't know of any data that says right to work undermines union organizing. In fact, it can be just the opposite, as I mentioned in the colloquy with one of your colleagues. I think this is another fallacy that's being stated here to support this legislation.
Well, we have the greatest economy in the world. Every business I talk to is looking for workers. I think, obviously, it's a great opportunity for those in the work. If I tell young people, I've never seen opportunity like this before in my lifetime. So we're grateful for that, and thank you, and I yield back.
Ms. Underwood of Illinois.
Thank you, Madam Chair. I'm so glad that we're having today's hearing as part of the committee's ongoing work to protect the basic rights that American workers have fought so hard to win. I'd like to thank Mr. Alvarez for sharing his story and for so clearly describing the American dream and the challenges and opportunities that you've gone through in your career, and I appreciate your willingness to share it with the committee today. Thank you. I'm incredibly proud to co-sponsor the Protecting the Right to Organize Act. We know that unions provide an essential foundation for working families in Illinois' 14th District and across the country. Recent research from the University of Illinois, for example, highlights the link between unions and better wages for all workers, even those who aren't union members. And so, Mr. Griffin and Ms. Garden, in addition to better wages, how do labor laws that empower unions to benefit workers, how do labor laws that empower unions benefit workers, including those that aren't union members?
Thank you for that question. So I guess I would emphasize that labor laws protect workers, including non-union workers, by protecting their rights to engage in collective activity at work, even short of electing a union to represent them in bargaining. That can mean things like talking with their coworkers about how much they earn, which could reveal discrimination in pay practices that workers can then either take to their boss and try to remedy or take to court if that's appropriate. When employers are aware that employees have the right to talk to each other, it can also encourage them to behave better.
Great, thank you. And Mr. Griffin?
Yeah, the classic example of collective action in a non-union workplace is a fairly old Supreme Court decision called Washington Aluminum, where people were working in a very cold environment and they wanted heat. It was a completely non-union workplace. And so they walked off the job to force their employer to provide heat in a frigid workplace. And they were discharged. And the Supreme Court, in an opinion by Justice Black, said they were engaging in conduct that any civilized country would recognize as lawful. And the Supreme Court agreed with the board and ordered the reinstatement. So to Professor Garton's point, even in an unorganized workplace, the right to engage together to address workplace concerns, immediate workplace concerns, is protected under the National Labor Relations Act, and very importantly so.
Thank you. Some 60% of Americans have a favorable view of unions, and some 48% of workers who are not in a union would like to belong to one. However, only 6% of private sector workers belong to a union. Mr. Griffin, why is there such a wide gap?
I think there's essentially two reasons. Organized corporate opposition, which manifests itself in both legal opposition and illegal opposition, threats, firing, and things like that. And the law's inability to translate, to provide an efficient mechanism to translate people's desire to be represented by a union into actual union representation. So I think there's really two reasons for it.
Strong laws that protect and empower workers must ensure that workers are clearly informed of their legal rights. Ms. Garden, in your testimony, you state that it is difficult for anyone who is not a labor lawyer to know what's allowed and what is not under Section 8B4 of the NLRA. How will the PRO Act bring clarity to this area of law?
Great, thank you. So Section 8B4 is worded in complex language. The NLRB's own website calls it mind-numbing. That level of complication is exacerbated by several decades now of Supreme Court and board decisions putting glosses on 8B4, often to attempt to save the statute from unconstitutionality. So that means not only do you need to read and understand this complex language, you then need to read a whole stack of board and court decisions to know what you can and cannot do. This isn't a problem that can be solved by tweaking 8B4, and so the PRO Act appropriately just goes back to the drawing board by getting rid of it.
Thank you all so much to our witnesses for being here today and for our friends in the audience who fight so hard on behalf of working families every day. We just heard one of our colleagues from another state lift up that state as a great place to do business, and yet workers don't have the right to organize. They don't have the right to come together and bargain for safe workplaces or vacation days, as Mr. Alvarez said. And that, to me, cannot be a great place to do business. We're talking about a place that limits women's reproductive rights. That cannot be a great place to do business. And so here in the House, I'm so glad that we have an opportunity to support legislation like this. And with that, Mr. Chairman, I yield back.
Thank you, Madam Chair, and I'd like to thank the panel for being here today. Looking at H.R. 2474, the Protecting the Right to Organize Act, Modernizing America's Labor Laws. People do have a right to organize, and they also have a right not to organize if they wish not to. And that's what, Mr. King, I'd like to sort of focus on a little bit. There's been studies that show 90% of workers are represented by a union today that have never voted for that union to represent them in the first place. Last Congress, committee Republicans held several hearings on legislating reforming the National Labor Relations Act and the Labor Management Reporting and Disclosure Act to make unions more transparent and accountable to their membership. Drawing from your background and experience, What are your thoughts regarding the relationship between labor union accountability and transparency and the steady decline of unionization in this country?
There's a great schism. I'm familiar with the study you mentioned. It's a Heritage Foundation study where 90+% of the workers that are represented today never had an opportunity to vote. As we have talked about here today, Mr. Keller, there is less and less resources apparently being devoted by labor organizations to organizing and member opportunity and more for political activity, which leads to the worker, the union member, not having the attention that she or he should from their organization. I would disagree with Mr. Griffin in that the stats are clear that we have a low, a 75-year low of union petitions being filed in this country. And as mentioned a couple times already today, less than 0.1% of the eligible workers in this country were sought for membership in 2018. So there appears to be a great disconnect. I don't know necessarily why. I'll leave that to the labor union leaders. But I think your question is spot on.
Are there any things contained in H.R. 2474 that would reform or make reforms that make unions more accountable to and transparent to their membership?
I could not find any. As I mentioned previously, all of the legislative proposals in this bill harm employees and employers, including only fines on employers. It's a very one-sided proposal.
Well, you mentioned fines on employers. H.R. 2474 undermines the original intent of the National Labor Relations Act by imposing severe monetary penalties up to $100,000 on employers for unfair labor practices, including on individual officers. Unions can also commit unfair labor practices under the NLRA, such as earlier this year when the United Food and Commercial Workers Union tried to punish a worker for choosing to work rather than participate in a strike. What are some other unfair labor practices unions can commit?
Failure to refer in a hiring hall situation and an individual that does not agree with the union for work, failing to permit a rational way for a member to resign. We've had numerous recent cases on that. Failure of the union to permit our democratic process of voting, failure of the union to permit an individual to be a dissident and oppose the union and retaliation for such resistance, failure to provide duty of fair representation for the individual member in grievances and arbitrations. That's just a partial list. It's really remarkable to me, Mr. Keller, that this legislation ignores totally any type of sanction on the union. And finally, per your point, not only do we have fines, this bill also proposes punitive damages and attorney's fees, again, only against employers.
Yeah, that actually answered my last question, because my question was, does the bill apply the same punishments to unions and union bosses found guilty of unfair labor practices as it levies on employers? And I guess the answer is no on that.
And Mr. Keller, if we're going to go down this path of putting civil penalties in the National Labor Relations Act, which I submit is not a good idea, but if we're going to go down that path, let's at least do it on an equal basis. Let's at least hold that rogue union responsible just like the rogue employer. We do have outliers. There are certain unions and employers in this country that need to be held accountable, but this is not the solution.
I would agree with that, and I thank you for that. I just want to make the important point that people in this country do have a right to assemble. They also have a right not to assemble and not to associate. And I think this bill goes a long way in taking rights away from people to freely assemble or not associate with certain organizations. I yield back my time. Thank you.
Thank you so much. Mr. Morrell of New York.
Thank you, Madam Chair, for holding this important hearing, and thank you to all the witnesses for being here to share your expertise. I grew up in a strong union home. My father was a proud lifetime member of the Plumbers and Pipefitters Union, Local 13 in Rochester, New York, which instilled in me and my family a deep appreciation for the benefits that unions provide American workers across the country. However, for decades, we've seen the erosion of workers' rights to organize and collectively bargain, which is why this hearing is so important. So on behalf of my constituents in the 25th Congressional District in New York and the working men and women throughout the country, I'm proud to support the committee's work to advance legislation that protects fundamental rights of nation's workforce. I have a couple different questions, but first, if I could just start, and I think perhaps, Mr. Griffin, this might, you might be able to help me with this. I thought I heard earlier, or there seemed to be the suggestion made that workers who engage in violent behavior when picketing is somehow have some protections in this bill or could not be prosecuted. I don't think that's true. I know there's been bills introduced designed to outlaw what I think is already illegal threats, robbery, physical violence. Is there anything that you know of that protects a worker from engaging in otherwise unlawful activities that relates to organizing?
No, I think, thank you for the question. No, I think what was being referred to was anyone who engages in violent activity is prosecutable under various statutes, certainly prosecutable under state law, and there's nothing in this bill that addresses that in any way, shape, or form. I think what was being referred to was a decision of the Supreme Court under the Hobbs Act, the Emmons decision, which addresses whether, in addition to all the other ways you can be prosecuted, you can also be prosecuted under the Hobbs Act if you are a union member or agent or for engaging in violent activity in the course of achieving a legitimate union objective, which was, in that instance, a collective bargaining agreement. But there's nothing in this bill that addresses that one way or the other.
Good. And I just wanted to make it clear, Madam Chair, and to the members that I just wanted to clear that up, that this isn't, there's no blanket protection for people who engage in otherwise illegal or unlawful activities. I want to go back because there are barriers that often restrict Americans from taking collective action for better wages and benefits. When the NLRA was amended in 1947, it put in place substantial restrictions, as I understand it, on workers' free speech rights, and many of these have enabled the National Labor Relations Board to prosecute workers in situations where they were peacefully seeking to improve labor conditions. And we've seen crackdowns on even the simplest form of collective bargaining actions organized by employees. And I wanted to point out one example that occurred recently in the case before the MLRB between the International Brotherhood of Workers, IBEW, Local 357, I believe, and the Desert Sun Enterprise Limited. In the case, MLRB ruled that Local 357 made an unqualified threat simply because it copied a second company on a letter regarding its plans to hold a picket at a common status shared with the company the union had a dispute with. And they were deemed to be wrong because the union did not provide a more dry dock assurance. I noticed, Professor Garden, you identified and addressed earlier, both in the conversation with Chairman Scott and in your testimony, the more dry dock assurance. But in my view, it violates basic freedom of speech rights because it means a union's advance notice of picketing may violate the law, even if the actual picketing is completely lawful. And I wondered, the ruling denied, by the way, IBEW workers their fundamental right to take collective action against an employer that paid its employees for far less than the area standards confirmed by the local labor commissioner's wage determination for electrical work. So, if I can ask you, and I apologize, you're going to have to have a quick response, but how does that more dry dock standard impact workers' right to take collective action? Could you just describe that?
Absolutely. Well, the case you're talking about reveals this sort of fundamental irrationality, right? So a union sends a letter to a neutral employer, says, you know, maybe it's just a heads up, right? We're going to be picketing a struck employer at your site.
And that's a requirement of the law or of the standard?
Well,
notice?
So the picketing would have to comply with these more dry dock factors in order to be entitled to this sort of safe harbor. The union can have every intention of intending to comply, and I apologize for going a little bit over, just may nonetheless find that it's committed an unfair labor practice because it didn't know it had to sort of say, oh, and we're going to follow the law, right? Something we don't usually say when we're conveying information to another person.
Thank you.
Thank you, Madam Chair.
Ms. Stevens from Michigan.
Thank you, Madam Chair, and thank you to our witnesses for the second hearing on the PRO Act that we are having here today. For many of us, this is what we came here for. Coming from southeastern Michigan, a rich and profound history of labor traditions, the birth of our middle class, and the movement forward, join my colleagues in support of this legislation, and also the opportunity to promote a 21st century labor movement that allows us to embrace the future of work and its changes to regional economies like the one I represent. As the co-chair of the Future of Work Task Force in the New Democrat Coalition, we're laser focused on how to make sure the rules around labor standards and work meet the realities of this 21st century economy. And as work continues to evolve, and it's also something that I monitor closely as a member of the Science Committee, and new types of worker arrangements emerge, we must critically examine how the tests for employment interact with the ability for small businesses, emerging tech companies, and tech companies writ large to succeed in innovation and employment growth as this legislation moves forward. So, Ms. Garden, I know that there's multiple exemptions that are being sought to this ABC language at the some of which is at the state level. How can we ensure that employers have these clear and reasonable instructions to classify employees while also maintaining protections for workers?
Great. I mean, the ABC test is really very clear. It will help people to know whether they're an employee or whether they're an independent contractor when they start work. The previous test, the sort of multi-factor test from the restatement of agency, leads to gamesmanship. It leads to protracted litigation as the sort of multi-year litigation over whether FedEx drivers were independent contractors or not revealed. So the ABC test, I think, really sort of helps everybody plan for the future by making it clear who's an employee.
And just to be clear, does collective bargaining allow employers flexibility in what they can bargain for at the table with their workers?
Oh, absolutely. There's no such thing as a one-size-fits-all collective bargaining agreement. That's the nice thing about a system of private ordering, like bargaining.
Great. And Mr. Griffin, your testimony discusses the value of protecting rights under the NLRA, but those rights have not been obviously fully exercised under a number of cases, and maybe for some reasons. If you had to prioritize, what are the top 3 weaknesses in the NLRA that would make the law more effective in protecting the rights of workers to organize and collectively bargain?
Well, I think many of them are addressed in this legislation, and the reason that they're addressed is because they're not just my view, but they're pretty much consensus view. The first is the coverage of of how many workers are covered. There are a lot of different exemptions, and there's the independent contractor complicated test that doesn't allow for coverage of a lot of people who really are properly classified as employees. Secondly, the remedies under the Act are weak and really don't penalize employers sufficiently for engaging in unlawful conduct. And third, there is a lack of people's understanding of their rights. People don't know what their rights are. And this law joins many of the other federal labor standards law by adding a specific notice posting provision that requires people to be advised of their rights in the workplace.
Yeah, great. Thank you. Those are my questions. I yield back the remainder of my time.
Thank you so much. And now, since all of the committee members have spoken, let's welcome Mr. Kennedy of Massachusetts. Thank you.
Thank you, Madam Chair. I'm grateful for the opportunity to join you today. Thank you for holding this important hearing and for this critical piece of legislation. Over the past 4 decades, our economy has shifted dramatically. Companies and corporations have opened, shuttered, and opened again. Jobs have moved, jobs have changed, and some have vanished. But if there's a defining theme over the past 4 decades, it is the systematic assault on worker clout that is leading to stagnant wages, historic economic inequality,
and all undermined by a sustained attack on union labor and bargaining rights. While CEOs on average make 287 times more than those they employ, a minimum wage worker cannot afford a 2-bedroom apartment in any corner of our country. That is a crisis that will only grow worse if this government continues to turn a blind eye, or even worse, continues to roll back protections for workers. And no one in this country will feel that pain more acutely than contract workers who are denied decent protections and benefits. At a moment when we are only years away from potentially half of American workers being classified as contract workers, we're on the precipice of an economic disaster. Instead of pointing to market forces and ceding influence to corporations, it's time that Congress step forward, protect our economy, protect those employees. So, Mr. Alvarez, to begin, do you know the personal stake that XPO CEO has in your company?
No, I don't.
It's about $2 billion. Do you know how much he directed his company to spend in a stock buyback this past year?
No, I don't.
It's about $2.5 billion. Do you or any other additional contract workers, your colleagues, benefit from the stock buyback? Did they benefit at all from that stock buyback through a bonus or a raise?
No.
A dime of that $2.5 billion? No. Mr. Alvarez, if I can ask, if you were to be classified as a full employee from XPO, which, if I understand, you wear XPO clothing labeled with XPO, do you not?
Yes.
And if you were actually classified as a full employee of XPO, how much more would you earn annually?
That is something what coworkers will bargain for.
And would XPO contribute to any sort of retirement account for you if you were a full employee? Would you be able to benefit from from a retirement account if you were a full-on employee?
Yes.
Do you know how much they would make in that contribution?
No, that was something we will bargain for.
But at the moment, because you are not actually a full employee, but you are a contract employee, you wear their apparel but do not benefit from that arrangement.
Correct.
So, why don't we start with Ms. Garden, Professor. I'd like to talk to you about an emerging industry in the workforce that employs our tech sector. Google employs over 200,000 workers today. More than half of those workers are classified as temporary workers or contractors. Facebook employs roughly 15,000 contract moderators globally, many working in poor or even dangerous conditions, viewing some of the worst content that exists on the internet with very little support, resources, or even job security. So, Professor, could you explain to me how the PRO Act would and the end of employee misclassification could help us prepare for this new workforce?
Yeah, absolutely. One thing that has changed as work has evolved is the sort of technology that companies use to control how work is done in ways that the companies say don't require them to take responsibility for the welfare of those workers. So the PRO Act would help to change that by adopting a clear definition of who is an employee that comports with most people's sort of understanding of what their job is and who they work for.
Mr. Griffin, same question to you.
I would give essentially the same answer. I think that if Google is classifying people as contractors, and if those people would be employees likely be covered by the National Labor Relations Act if they were determined to be not independent contractors under the ABC test, then they'd be able to exercise rights that they're not able to exercise currently.
Have you seen, in your opinion, sir, an erosion of worker protections, worker clout over recent American history?
Yeah, well, I think what I saw, I had a number of cases when I was the general counsel that involved gig economy employers that had classified people as independent contractors. And I'd note that in no instance did they come forward and produce a legal opinion that went through the 10 factors and said, we considered this before we classified the people. They just started out on the theory that they wouldn't treat them as employees. They would not provide them benefits or the protections of the National Labor Relations Act. And so, yes, I've seen that in a number of gig economy.
All this at a time when corporate profits are at a historic high.
The facts are what the facts are.
Thank you. Yield back.
Thank you. I remind my colleagues that pursuant to committee practice, materials for submission for the hearing record must be submitted to the committee clerk within 14 days following the last day of the hearing. preferably in Microsoft Word format. The material submitted must address the subject matter of the hearing. Only a member of the committee or an invited witness may submit materials for inclusion in the hearing record. Documents are limited to 50 pages each. Documents longer than 50 pages will be incorporated into the record via an internet link that you must provide to the committee clerk within the required time frame. But please recognize that years from now, that link may no longer work. Again, I want to thank the witnesses for their participation today. What we have heard is very valuable. Members of the committee may have some additional questions for you, and we ask the witnesses to please respond to those questions in writing. The hearing record will be held open for 14 days in order to receive those responses. I remind my colleagues that pursuant to committee practice, witness questions for the hearing record must be submitted to the majority committee staff or committee clerk within 7 days. The question submitted must address the subject matter of the hearing. Before recognizing the ranking member for his closing statement, I ask unanimous consent to enter the following materials into the record. Letters from the Amalgamated Transit Union, the Laborers International Union of North America, and the United Steelworkers in support of the PRO Act. Without objection, so ordered. I'll now recognize the distinguished ranking member for his closing statement. Mr. Wahlberg.
Thank you, Madam Chair, and I would vote for any of the pronunciations of that word, and I would ask my staff never to put that in front of me either. I do ask unanimous consent to place in the record letters from the following organizations opposing H.R. 2474, the Coalition for a Democratic Workplace, the International Franchise Association, the National Association of Home Builders, the American Hotel and Lodging Association, Associated Builders and Contractors, and the U.S. Chamber of Commerce. Thanks to the panel for being here, and thanks, Madam Chair, for a good hearing. I say that because this hearing, I think, at least I think, made crystal clear the stark contrast of the competing agendas on whether union boss success should be priority number one or employer success should be priority number one. I truly believe that employees and employers being successful together only extends the opportunity for success. I would also hasten to say, as a former steel worker at U.S. Steel Southworks, south side of Chicago, number 2 electric furnace, that my job there was safer, my benefits were better than they would have been had not the union involved themselves in providing some enhancements over the years to the point of 1969 when I came there and worked. And there's a place for that. But there's a place for each employee to make the decisions on her best or his best self-interest on the basis of value of what they purchase or join or involve themselves with. I believe the best way to bring success to the employee is to also allow employers to succeed as well. And nothing that I see in this bill, the PRO Act, H.R. 2474, I believe offer that opportunity for both sides. In fact, I think it takes us backwards. Choice and flexibility are key, I believe, to success. Choice and flexibility. This bill offers no flexibility, except to one side. That's not flexibility. It takes away choice, even for employees. in my state, where the citizens supported a right to choose, a right to work for employees in a long-standing union state of Michigan, the home of the auto industry, motor capital of the world. They made that choice. And employees still have a choice whether they can join or not join a union, and they make those choices. There were statements made today with broad sweeping brushstrokes about the need to have this legislation because of income levels, income inequality, the middle income going down, and all of the rest. I would not hesitate to state they were broad brush statements, not making apples to apples judgments, but rather apples to oranges or banana judgments. And I'm pleased that we will insert in the record alternative viewpoints with a much clearer understanding of what was there. But let me just state, median household income, for instance, reached its 5th straight record high last year, over $61,000, median income. Those are the middle-class workers that I represent in my district. And I could go on with actual statistics, not taking outside outliers and pulling them in. And I think we need to understand that as well. Mr. Alvarez, thank you for coming all the way here. You're an individual at this point in time who is highly sought after. I would encourage you to come to Michigan. I know you like California. It's a lower cost living state in Michigan. And there are 60,000, not simply in Michigan, but at this point in time, the last number I saw was 60,000 truck seats unfilled. You are highly sought after. I was put into the driver's seat of a 18-wheeler and encouraged the double shift, double clutch a lot better than I actually did. They didn't hire me, but they said they would train me and they would put me in a seat. And these would be in seats in either Teamster union operations or private contractor operations as well. You have choices and you have skills. Whether you go into aviation or not, you have skills that are marketable now. This legislation, I don't believe, would assist in that. So, Madam Chair, I appreciate the chance to have this crystal clear difference hearing today, but I would certainly hope we wouldn't go backwards, that we would move this legislation that I think would ultimately hurt the opportunities for people to have those choices, make those decisions, and have the flexibility to do what America's always proposed. Thank you, and I yield back.
Thank you, Mr. Wahlberg. I now recognize myself for the purpose of making a closing statement. Thank you again to all of our witnesses for your testimonies today. Today we heard compelling testimony on how the changing relationship between employers and employees is undermining workers' ability to exercise their collective bargaining rights and negotiate for better wages, benefits, and working conditions. We heard from Mr. Alvarez how hard it is for him, and we learned from Professor Garden as the number of subcontracted freelance and third-party workers increase, employers are incentivized to exploit loopholes in the National Labor Relations Act to misclassify employees, subcontract work to evade labor laws, and restrict workers' rights to peacefully protest. To make matters worse, the Trump administration is further enabling employers to exploit these weaknesses in labor law. From attempting to reverse the Browning-Ferris decision to denying super shuttle workers the right to organize, Republicans at the National Labor Relations Board continue to erode workers' rights to join a union and to negotiate with their employers. But more importantly, we discussed the long overdue steps the Congress can take and should take to ensure our nation's labor laws protect the right to organize. By passing the PRO Act, we will provide workers with the safeguards they need for a modern economy. This bill will prevent workers from being misclassified as independent contractors and will prevent employers from evading their obligations under the law. And we will repeal the provisions that violate workers' First Amendment rights. Once again, I thank the witnesses for being here. Thank you, Ms. Garden, Mr. Alvarez, Mr. King, and Mr. Griffin. And I thank my colleagues for a constructive Health Subcommittee hearing. If there is no further business, without objection, this committee stands adjourned.
Always a pleasure.
Agreed.
Hey, Bill. Yeah.